What's up, everybody? It's another day and another Sarah Boone hearing. This one gets interesting when she argues with the lawyer from the jail. And you can tell exactly how that lawyer from the jail feels about Sarah Boone, but is he right? And is that going to be the way it continues to go? Because there's so many things brought up in this hearing that I think are a great question for us as society. What do we expect and what do we want to give defendants representing themselves in 2024? Not 1950, not 1980, not even 2005, but in 2024, what do we expect? What are we going to give them? What is fair? What is just? That's the question we have to have on our mind, regardless of who the defendant is, because Sarah Boone is the person in the seat right now that's bringing up these questions because she's advocating for herself and she's fighting for her rights. So we're going to discuss it. We're going to break it down today. We're going to listen to this hearing. I can't wait to hear your thoughts. Let's get into it. All right. Make sure you guys hit that like button and subscribe if you haven't already. Playing pickleball tomorrow, and I can't wait because I got some new kicks. Might be doing a little deal with them. We'll see. I reached out after I got them. I was like, I think I love them, but I got to test them. I got to test them on the courts tomorrow. So I will report back and see how things go. But the Boone hearing starts basically with discussing not having a laptop, internet, all of those things. We're going to hear from a representative from the jail when we get into those, generally speaking. But the first argument that Sarah Boone actually makes, and a lawyer from the media is also at this hearing. She filed a motion to intervene. The media wants to be there for anything that's happening, including evidence viewing in the courtroom. Now, we're going to hear some horrible arguing on the part of Sarah Boone, but we're going to give her some props for the fact that she continues to advocate for herself. She continues to try to make sure she doesn't get railroaded, and she brings up some good questions. Some of them are not great making the argument through this process, and I'll talk about kind of, I think, what would have been a better argument, and then it may end up being null and void at the end. But let's go ahead and listen to how she argues the fact that she wants her privacy from the media here.
Concerns is regarding my case and the whatever is left evidence that is not already on the internet or posted anywhere on social media. And I'm wondering what the reasons for the court, other than sensationalism and exploitation, purpose would be for them to watch me look at the remaining bit of my evidence that has not been politicized. Again, my main concern is it is for exploitation purposes, which has already been greatly applied to my case in many, many ways globally again. And I see on the motion to intervene for WFTVs, my question is, why is this an important criminal proceeding? And why do they need to have it monitored? I don't understand the reasons why just for this one. I'm not asking for all of my other hearings to be closed. Simply, this is my one and only. It is my right to have some kind of privacy regarding my case. Nonetheless, it is an active case. It is my understanding that some information is not able to be publicized due to privacy. And it's not their right to pry and exaggerate, which is the whole point of why they want to be included in this one and only most important hearing that I would say that I have on the horizon.
Number one, definitely not the most important hearing. Number two, she's totally mistaking this argument. It is not a privacy right. These hearings, these trials are public. The public has a right. The media has a right. These are public courts. This is a public system, especially in Florida. Now, her best argument that she fails to make throughout this entire 5-minute argument here is this is not something that's normally televised or streamed. Media is not usually at the evidence viewing. And because I don't have a lawyer, am I getting punished now to having this open to the media, as opposed to normally, or if I had a lawyer, or if I was a lawyer and I could do this, or if I wasn't incarcerated, I could do it somewhere else other than the courtroom. It shouldn't really be open court like a normal hearing. But she's wrong to say, oh, the media is sensationalizing it and this is my privacy and I don't want them to be able to, get clicks out of it, which is what the media does. But in reality, she really is missing the boat on this argument. She does not even make the best argument that she has in this situation. We'll keep listening in here. It might not matter, but it's just interesting to hear her, because sometimes she'll make a decent argument. We'll say, okay, it's kind of a decent argument. Sometimes she completely misses the boat and you're like, yeah, that's why you need a lawyer. And this is one of those times.
The press doesn't have a right to press themselves into everything in regard.
But they kind of do.
to my active criminal case. And I feel that from this, one meeting should be closed to the press so I can rightfully, lawfully do what I need to do in order to properly, rightfully, and lawfully defend myself. At this point, I feel that there's nothing even suppressible in my case that is not already on the internet and have been spread all on the internet. I'm trying to salvage whatever it is that I can possibly to have a card to play at least one in the end during my trial. I do not feel that it is right lawfully to have them included in this hearing, this one hearing, and I'm asking for their admittance to be closed. This is an active, ongoing investigation and case.
And every case that they cover is ongoing and active. So then the media attorney steps up to the plate and makes her argument.
Why the media wants to be there, what transpires in the courtroom. Ms. Boone's. Thank you, Your Honor. I think Ms. Boone's argument really flips the question. It's not why the media wants to be there. What transpires in the courtrooms, even pretrial hearings, is public property, and there's a right to be there. I'm not going to go over the Lewis test because I know Your Honor knows it well, but it's a very strict standard, and it's the plaintiff's burden to meet. I haven't seen a case in Florida.
By plaintiff, she means the movement, which is Ms. Boone.
Where a criminal case was closed on a defendant's privacy concerns. We're not talking about third-party privacy concerns or something that's not inherent in the proceeding. This is the evidence. And even with respect to the evidence and it being an active, still an active case, Florida law is clear that once discovery is provided to the defendant and accessible to the defendant, that becomes public record. That too becomes open to the public. So with respect to the first part,
unless it is something that's been specifically sealed for some other reason, she's right. And that's why this was an uphill battle. And the only real argument is, Judge, but this isn't a normal thing that happens in open court. And because it's not a normal thing that happens in open court, it should be treated like a closed room meeting, which is usually what it is. I just happen to be incarcerated and forced to represent myself. So we should treat it as if it's a closed room and not a public and open hearing, because it's not really a hearing. It's a meeting between me and the prosecutor.
The analysis, I don't think the defendant has established that this hearing needs to be closed to protect her fair trial rights. Publicity isn't necessarily synonymous with prejudice. He has to show widespread, adverse, hostile publicity, and then specifically show why that publicity is going to be aggravated by access to the September 3rd hearing. The discovery in this case has been public. I'm not sure what specifically would be aggravated by access to the hearing. So I don't think she's met that first burden under Lewis.
And she's right. We already know all this stuff. How's it going to get any worse? It's really not. Manley said, Sarah should have argued that the press in the hearing would pollute the jury pool, making voir dire impossible. So the problem with this is the stuff's already out there. And a lot of the prejudicial evidence is already out there. It's already public. People have already seen this. This is really not going to make it any worse. If you're balancing this, I don't see how the public is not allowed at this hearing or this open court meeting. The only way really you keep the media out is you don't call it a hearing. It's not an open court proceeding. It's just a meeting between the prosecutor and the defense, which the media doesn't have a right to be at, especially if it's a private meeting. More on that later. Speaking of more on that later, Tammy said, I'm surprised Sarah didn't file a motion for the JAC funds to provide her with pretend judge costumes so she can practice for court in her cell. She's going to need a curly white wig and a black robe with a lace collar ASAP. Well, she did petition for more money for something, which we're going to get to at the end of this hearing. But let's jump ahead just a little bit to hear what the judge has to say after Sarah Boone makes her final argument.
Closing remarks from you, Ms. Boone.
Yes, Your Honor. First, I'm only asking for this one hearing, which is a very important hearing. I believe that the press is simply...
So far, you're only asking for this one hearing. You've asked for other things, and my guess is if you won this, you'd ask for more in the future.
...in it for ratings and publicity.
The press is in it for ratings and publicity. It's like Captain Obvious. That's what the press does. Now, I get what she's saying, but she shouldn't be arguing ratings and publicity, but instead sensationalism and poisoning the jury pool like they argue, which again is a losing argument, because that's also kind of what the press does. But to say that they're doing this for ratings is like, yeah, that's not going to be a reason to keep the press out. Now, moral and, normal everyday argument, maybe this is a valid argument, but legally speaking, it holds almost no water.
Evidence is active, and I'm trying to salvage the little bit of anything that I have pertaining to my evidence that is not available online, which would be in that hearing. And I also heard she was speaking in regards to once discovery has been received, it is therefore public record. I just received my discovery for the first time, and I'm still reviewing most, if not all of it. And I have not had the time to go through all of it, but I literally, on the record, just received my discovery to even have an opportunity to prepare to review any of that. And in regards to the hostile publicity, I have letters, I have messages, I have tablet information. I have an entire folder dedicated to publicity in more than one way as being hostile, good, bad, ugly. It's publicity. This will incredibly enhance my inopportunity to have a fair trial because of the already millions of viewers that I have in my case, literally in my case. This would just contribute to it even greater. I'm not asking for all hearings to be closed. I've not had an opportunity to review my discovery, which I just received. I have an entire folder and more information and letters and evidence in regards to publicity, hostile, any type of emotion that you can come up with. I have received from Australia being the most recent. So I do not believe just because they would like to, again, in my opinion, for ratings and for publicity, it's one hearing. There also is a solution that I believe, my understanding was that this could be held at the Orange County Sheriff's Department. The question was in regards to transport, which is a possibility. It was a matter of the decision being with the court. I would like to be able to properly prepare for this.
She mentioned that they could do it at the jail. Somebody said that she mentioned the jury. Yes, she did mention people seeing it and over sensationalizing it and making this trial harder. Absolutely. But then the prosecutor pipes in after the judge starts to rule, which I think is very interesting. It's like, why didn't we start with this?
Would I have received everything prior as everyone else did? Having the internet would have helped also in regards to receiving the notice via email, as everyone else had. I'm sitting in front of you. Yes, I'm handcuffed, but I am unprepared for this rebuttal in regards for me to have privacy, expected privacy to a certain degree, and by law, to have this one hearing closed. And we also have an active case that is ongoing, active evidence, and there's a solution for it to be held at the Orange County Sheriff's Department as well.
Okay. Anything else from the state?
I wasn't going to bring it up until after the ruling on the motion, but the parties have reached an agreement to do this on our own.
He was going to wait to see what the judge said. If the judge was going to say no media, then maybe we would have done it in the courtroom. But if the judge says media is allowed, obviously Sarah Boone's not going to want to do that. But it turns out the state and Sarah Boone have already come to agreement to do this evidence viewing elsewhere, which would then not necessitate the judge to rule on the media because the media wouldn't be at the jail if they were going to look through this evidence. But it seems like that is actually what's going to happen, which I think is good. The judge still makes a ruling and Sarah Boone's motion to exclude the media is denied.
And as soon as that is accomplished, if it's accomplished to both of our satisfaction, then I'll let the court know so you can do it in time.
Okay, we'll address that momentarily. Ms. Fugate, anything else? All right. Under the Miami Herald versus Lewis case, ma'am, Ms. Boone, you had the burden of producing evidence and proving by greater weight of the evidence that closure is necessary. What has been presented today has failed to meet that burden. Your motion to close the September 3rd viewing is denied.
Okay, then they start to talk about how is she going to know about hearings because of the mail and the delays. And the judge is like, I told you in open court, everybody heard me. So we can just understand this is going to happen every time there's a hearing. Every time she doesn't think she gets something quick enough, she's going to complain about it. We're just going to hear a little snippet of that
Today, and that we would addressing the issue regarding the media's participation. And that's when you asked for the case law. I said, I will give it to you. Absolutely. And it was all mailed to you on the 9th.
I'm not ever sure of what it is that I'm supposed to be doing with, I guess now, oral and also in writing. And again, I'm sitting here waiting empty-handed for everything that was mailed to me the day before yesterday and or could have been readily available on the internet, which I do not have access to. So I'm guessing that your verbalization of the order that you read to me, which I have not received, is supposed to suffice.
Ma'am, you were told about the hearing in open court on Friday, August 9th.
If I knew to be prepared, I know that everyone knows that I would be prepared, which I am unprepared because of.
Everyone knows she would be prepared, Judge. Everyone. Point is, like, sometimes there are notice issues, but she was absolutely told about this. I don't know. Now, they are saying that, or she is saying that things that were mailed to her are not getting to her in time. That's a problem. They've got to fix that. They have some potential solutions later on in the hearing. And the state then describes, again, the alternative to doing it in open court is doing it elsewhere. Will they take it all out, show it to her, make sure it's in evidence bags and opened and closed and sealed appropriately to not hurt the chain of custody. Then the judge gets on the record. Again, this is always important when you have a pro se defendant, but they get on the record that both sides agree to this alternative plan. And Boone's obviously going to agree because she does not want to have this in open court with the media there. That's her number one prerogative. And I got to be honest, this is where we give her the props. She went for plan A, but had a plan B ready to where she was going to be able to view this evidence without the media there. That was her number one prerogative. And she accomplished it, even though she lost miserably her motion. It didn't matter in the end.
Okay. All right. Then, ma'am, after having Mr. J explain that alternative solution to the evidence viewing, is that something that you would like to participate in?
Absolutely.
Okay. So then is it the parties' agreement to no longer have the evidence viewing here in open court on September 3?
That's the state's position, but again, been doing this long enough to know that you can never predict every possible hiccup. But I will defer to the court if you want to free up your hearing time now or wait until we're able to tell you that we're satisfied.
Okay. Ms. Boone, are you in agreement with that alternative solution?
At the Orange County Sheriff's Department,
Wherever the viewing is going to take place. I don't know that a specific location was identified, but yes, where it's going to take place.
I am.
Okay. So then here's what we'll do. I will keep the hearing for now. The deadline to have that viewing is set forth in the August 5 scheduling order and notice of.
So they're going to keep the hearing in case something falls apart where Sarah Boone doesn't agree to something and the state's going to be like, fine, we'll just do it in open court with the media there, your buddies and your fans. And so they know they have that leverage over her, but they're going to meet, they're going to go over it without the media. And the judge doesn't have an issue with that. And then we get to the freedom of movement again, where the judge wants to, very politely and respectfully discuss with Sarah Boone, what attire does she want to wear? And does she know the risks that she would be getting into depending on what attire she chooses? What do you think she's going to pick? What do you think she wants to wear?
To use a stun cuff. I understand that a representative from the public defender's office spoke to you about clothing and what they may be able to provide to you. Is there any preference with regard to clothing that you may have?
as opposed to a skirt and pants.
Correct.
Yes, I very much would prefer to wear a skirt.
Okay. So if you wear a skirt,
He would very much prefer to wear a skirt. No real surprises there. The Silver Lady said, Peter, Sarah didn't come up with that alternative solution the prosecution did. I will just tell you, Silver Lady, so many criminal defendants, when they start representing themselves, and you can look back at Darrell Brooks as an example, will not take a good opportunity when it's presented in front of them. So I think Sarah Boone knew she was trying for plan A, but had plan B that she doesn't have to agree with, but did agree with, had it in her back pocket, argued first, maybe when she felt like she was losing or after she heard the argument by the media, talks about plan B, whether she presented it or not, it was something that she was involved in. And I think that that's a good move for somebody representing themselves to have a backup plan that they know they're okay with if they can't get plan A. Peter, I was a juror once, so I have a lot of subject matter expertise. Even though your hair is far better than mine, I disagree. It should be open. So we're not disagreeing, Melvin. I think it should be open too. What I'm saying is the best argument for Sarah Boone would have been a lot of times this is not open, and it's not going to be open if they do it elsewhere like we would as criminal defense attorneys with the prosecutor. If reviewing the evidence, it wouldn't be open to the media anyways. Sherry said, oh boy, pickleball and some new kicks can't get any better than that. So I was making jokes to my buddies in the in our pickleball group chat, like, I'm so fast in my new shoes. That's what Maverick always says. Whenever he gets new shoes, he's like, I'm so fast in these. All right, let's keep listening.
Explained to you by Officer Barnett, the stun cuff is located on your calf Achilles area. It would be something that would be viewable by the jury. So do you understand that if you choose to wear a skirt for clothing purposes, that's going to be viewable by the jury?
I understand. My belief by you asking me was that maybe it could be moved to a higher place where it cannot be seen, or is it strictly to the one area?
As Mr. Barnett or Officer Barnett explained at the last hearing, how the stun cuff is affixed to a person, it is on the lower leg ankle area.
Okay. I'm not understanding why this is being asked.
Because I want to bring it to your attention that if you have a desire to wear clothing which would reveal the stun cuff, I want you to understand that it's something that the jury can and may be able to see.
I understand. Is it a decision I need to make today?
It's something that you need.
So again, to me, I don't know the answer. I don't know why she wants to wear a skirt. I don't know why. Maybe she thinks that'll present better in front of the jury. Maybe she thinks that's more sympathetic. I don't know. Battered wife syndrome, maybe something like that. But it could also be she's just being difficult because they very clearly said it would be under a pant leg around her calf. So maybe it's going to be a long skirt. I think she has limited. I think the person from the PD's office said they had 3 skirts and like 8 pair of pants or something for her to pick from. It's not like she's going to go to Macy's and be able to pick whatever she wants. So I don't know if she's just being difficult, but the judge is like, if you want to wear a skirt, go for it. But I got to let you know the risks you're running. They might be able to see that stun cuff.
Need to consider. If you're wearing pants, they obviously cannot see it. If you're wearing a skirt, they can see it. And you're making a intelligent, knowing decision that they can see that.
This is on you. And this judge is very smart. He's going to lay the record, protect the record, make sure everything's in the record, that she is waiving certain rights, making certain choices. She understands the risks and the benefits. She's making a knowing and intelligent waiver and decision that's so important in every situation like this.
That, and that you want to proceed with wearing a skirt. Your other option, if you do not like either of those, is the parties will remain, you'll be hands-free, as we discussed, but you'll have the leg restraints like you have today. And everyone will conduct everything from counsel's table. All direct examinations and cross-examinations, any questioning of any witnesses, any argument, any opening remarks or closing statements, closing arguments or opening statements will be made from counsel's table. You can certainly stand, but we will not have the opportunity to walk around the courtroom. Now, I know that we talked about in our last hearing that we would have another hearing when we have our trial case management in September, addressing the box as to where everybody would go to. And last week on the 9th, I said that we would limit access to from counsel's table to the podium, and we wouldn't be allowed to approach a witness or the jury, and those same restrictions would be placed on the state as well. I'm not telling you what to do. I'm just giving you a series of options. Because if you want to wear a skirt, you have to understand that the jury can and will be able to see that device that's affixed to your leg.
He's not even saying might. He's saying can and will. So if she wears a skirt and they see it, she knows. No surprises to her. Drank water down the wrong pipe.
And by my hearings that we have spoken about the stun cuff, they are televised, correct?
To the best of my knowledge, the media has participated in the majority, if not all, of the hearings that this court has had with you.
Does the court broadcast live, or is it uploaded to the clerk of the court's website?
What is broadcasted live?
My hearings, in regards to all of them, basically, but recently the stun cuff. Is there anyone that would know that I'm already wearing it if they could see it or not?
I can't speak to what everybody else knows.
So if I may, please, my options are pants hiding the stun cuff, or a skirt with it being visible, or I am able to sit here at the counsel's table with leg chains on, and no one is able to move except for here at the counsel's tables.
You certainly have the opportunity to stand, but we wouldn't be able to move around the courtroom, and those same restrictions would be placed upon the state.
They're literally giving her every option, treating her very fairly. This judge has treated her more than fair the entire time, in my opinion. Then they go through someone from the PD's office comes and talks about what options she has. The investigator comes up, talks about, the fact that she got the digital evidence. The judge discusses, let's play a minute of this just so we can kind of see the judge warning her about having her hard documents in her bunk that's not secure. And she's already complained about privacy rights in the past. So if something goes missing, hey, that's another knowing and intelligent waiver that she's making.
Do you understand that you told me that you live in a female dormitory with limited privacy? You understand by keeping those boxes there may be a risk as to other persons looking at them.
I don't have any other choice.
Okay, but do you understand that risk exists?
You do have a choice, the computer, the digital evidence.
Of course,
Okay, do you understand that there's a risk that those items could disappear?
I understand.
Okay, all right. And do you understand that it's your request and choice to keep those documents in your possession?
I do, and I'm also requesting in my letter to the captain and to the major to also be able to store all of the USB drives and the hard drive in my locked drawer, also for an extra security measure.
Okay, all right. I see that we'd have Investigator Lane here.
Okay, yeah, then Investigator Lane just comes up and talks about how he gave her the digital evidence. And then we get to the meat and potato portion of the hearing where the people from the jail come and talk about what extra things they can give Sarah Boone based on her requests and letters that she wrote to the jail. Before we get there, I'm going to hit a few questions. Julie said, how do I apply from the UK to represent her former Florida resident? Feel like I need to come back to Florida. She needs help legally, even though she's probably guilty. I don't know how you would do it from the UK. I know how to do it from state to state. What options would be available for contempt if the defendant is pro se and already in jail for refusing to follow the judge's instructions, etc.? So different sanctions can be levied against her. She could be kicked out of the courtroom. She could have to watch on a monitor. She could be bound and gagged potentially. She could be shackled. Those kinds of sanctions are still available to her and to the judge if she really, acts wild throughout this trial. Carrie said, Peter, what happens if she just throws her arms up and says, I can't do this. I don't know what I'm doing. The judge will instruct her not to do that. But if she does, my guess is the judge will just instruct the jury to disregard it. It's what happened in my trial. Disregard the outburst. We're going to get back to the case and representing, and Ms. Boone is representing herself. And she's just going to, the jury usually picks up on it. Like the jury was more annoyed with the pro se defendant I tried the case against as a prosecutor than I was. And he was very annoying. So juries usually pick up on that stuff. Now, if the state thinks it gets so bad that maybe they're going to feel bad for her or they request a mistrial, the judge can and probably would grant it at that point if she really did something wild. Kyle said, Peter, that shirt is tie-dye for her. It's like side effects to every decision she makes. Yes. All right. So now we get to the big chunk of this hearing that is, I can't wait to hear what you guys think about these requests and the back and forth between the attorney for the jail and Sarah Boone.
To address each request one by one, do you have a copy of the letter?
I do.
So this is the female captain of the female jail that is the one reading the letter from Miss Boone, and this is where kind of the back and forth starts. You'll hear a male voice. I'll let you know that's legal counsel that she's referencing from the jail.
And we can proceed with the 7 different items that she has requested. So if you want-
Actually, so with number 1, the request to have her review time extended, I can make the extension in the following fashion. We'd still have to collect the laptop at 4 p.m. This gives the staff and supervisors the ability to conduct the afternoon head count, conduct the meal dinner service, conduct the shift change, and then the evening head count. I am willing to allow her Sunday through Thursday to get the laptop and the USB drives from 8 p.m. to 10 p.m. and Friday night and Saturday night from 8 p.m. to 11 p.m. That is more than the requested time.
I mean, that's like an extra, 10, 15 hours a week with her laptop and USB drive. That to me is amazing that they're extending that. That's a huge win for her. And guess what? That would have never happened if she didn't ask for it. So whatever you want to say about her, okay? And I get it. Some people don't like her, and I get it. And I think the state's got a lot of evidence against her, and they're going to present it, and we'll see what the jury says. But as we sit here now, she's representing herself. Not a good situation, but she's fighting hard. It's the same thing people talk about like at hospitals. You have to advocate for yourself, or they treat you a certain way sometimes. And that's true. And we've had cases like that where it's gone horribly wrong. And at this point, she's fighting for herself, and at least something she's gotten here. She's gotten more than something, right? She's gotten freedom to move about the courtroom. She's gotten her hard documents and a computer. She's got an investigator helping her. She's got money for the investigator. She's got her, she's got the jail now extending the limited hours that they gave her to work on her computer and hard drive. So she is fighting for herself, okay? And Cheryl said, why does she get special treatment? I don't consider it special treatment. And this is going to be another question that comes up later when kind of the jail lawyer says, we're not going to give her special treatment. It's not special treatment if the judge or the jail determines that it's fair and just, and she needs it in order to protect her constitutional right to represent herself. So that's the question. And that's the question I want us to think about, this thought exercise that we go through today, and why I enjoy talking about this so much with you guys as far as like a social experiment goes. But what is fair in 2024? Keep that in mind as we listen to this.
Time that she has asked for additional viewing.
Ma'am, do you understand the extension that's being provided by the Orange County Jail regarding the laptop, that on Sundays through Thursdays, additional time from 8 p.m. to 10 p.m., and Fridays and Saturdays, 8 p.m. to 11 p.m.?
Correct, with them collecting it at the normal 4 p.m. time.
Correct.
Yes.
All right. Do you have any questions regarding that extension?
I do not.
Okay. Is that acceptable?
Very much.
All right. Moving to the next issue, Captain, the USB drive security.
Number 2, USB drives. It's a matter of security. The matter other than what it's originally or consultation with legal counsel.
We're going to skip through this part. It's just like, how they're going to make sure all that stays safe.
Of corrections regarding it being a matter of security, and how the USB drives are secured, controlled, inventoried, and confirmed to be in good working order.
I understand the process.
To the extent you're able to answer that question.
I would just chip in that, obviously the safety issues, and you can definitely distinguish between, paper copies and anything made out of metal, which is what the captain just testified to. That's the problem, it sounds like to me, is anything that could be a safety hazard is an issue for us.
So, ma'am, do you have any other questions regarding the Corrections Department position with regard to the USB drives?
What was the outcome?
It sounds like they're, unless I've missed something, it sounds like the Orange County Jail is going to continue with their protocol of storing, inventorying, and keeping the USB drives in accordance with the procedure as provided to you and read to you in open court.
And that's due to metal?
That's due to the reasons that were already identified. The matter of security regarding the drive being fashioned.
The last name of
Classroom, Captain Don DiGiovanni.
So that classroom is a multi-purpose classroom. It's used by programs and chaplain services. I cannot allow the use
This is her requesting use of the classroom in the jail that they use for different functions like chaplains and classes and things like that.
of a classroom. What I can offer is if the defendant is willing, I can move her to a housing unit and place her in a secure cell where no one will disturb her, and she can review and conduct case review. She will still have.
So they're saying they'll move her into a holding cell that is secure where she can be by herself to work on her papers. And that sounds decent. That sounds decent, but she's not going to have help from anybody else that may be helping her at the jail, from her friends. It's solitary basically, and it can be very miserable. I heard people saying things like, oh, they try to even give her this. It's like, this isn't as good as it may sound. It really is not. What judge will have it worse, this or Darrell Brooks's judge? Darrell Brooks's judge Judge Doro by a million worse than this judge. Will have it worse. Not that this judge is worse or whatever. Daryl Brooks is much harder to deal with than Sarah Boone. That's what I'm trying to say. Diva, Peter, I've been watching for an answer to the email about my case and I haven't gotten one. Do I need to send another one with a certain subject? So I looked at it. It's not something I specifically handle. I was trying to find somebody that I could refer you to. I haven't been able to yet, but it's outside of my purview normally. But I am trying to find somebody to give you a recommendation. Psycho Peta, you look great in tie-dye. Thank you very much. And Donna Mason said, I want Peter's shirt. It's on our merch site, lawyeryouknow.com. Check it out. Travel and Teresa, Peter, even though 2024, she's an inmate, there are so many operating procedures in a jail of that size. They can't just cater to her. I agree, but I have some more discussion points when we get to the arguments the lawyer makes. Let's keep listening.
Will have access to a shower. She will still have access to open day room time. She will still have access to phones, but the review and her location will be in a secured housing location where she would be the only person in the cell.
Ms. Boone?
Captain, is this Lima dorm?
K dorm.
Kilo. So my only options are being moved to the maximum security dorm or my bunk.
K dorm is no longer a maximum security. It's a multi-purpose area with inmates of varying needs being secured and housed there.
So it is not the maximum dorm any longer.
That's correct.
And I'm unable to utilize the classroom for an hour or two per day while it's dark the entire.
That's correct.
And if I may ask, other than it being accessed on a rare occasion of the 2 classes that do participate in that classroom, why is it that I'm unable to sit? And
I also think the jail wouldn't mind, just putting her in her own cell by herself and they don't have to deal with her and as much, and everybody else doesn't have to deal with her. Probably something a lot of them want.
be viewed by the officers at all times in my dorm comfortably, to be able to utilize the phones on a regular basis, the day room on a regular basis, to be able to go outside to recreation, to have just for fresh air. How is that? I'm not understanding specifically why the reason is it has to be so extreme from going to being locked behind a door 24 hours a day to not being able to just utilize the classroom for an hour or two per day.
Ma'am, you will still retain your rights as an inmate and have access to all the services and day room time that you currently have during the same operational hours. And instead of having to move items from a housing area into a classroom where the officer may have line of sight, I cannot guarantee that my officer will have continuous unfettered access to you to ensure the safety and security of that classroom while something may potentially occur in the housing unit. So as a matter of security to the rest of the inmates in the housing unit that you are currently assigned, my staff and the facility, I can make the accommodation where I could put you in a single person cell where you would have unfettered access, uninterrupted access to your case material, and still have my officers in the housing area where if you had a question or you wanted to take your shower during normal day room time, you would be able to do so.
I've been in a situation where I have been behind the closed doors also when I was made PC when I first got to Orange County Corrections Department. And if it's anything like that, I do not ever want to have that experience again. And to be honest with you, forgive me, Captain, but I do not believe that it would be this simplified. And nonetheless, I'm behind a closed door for 24 hours. Is there anything that I can do, any kind of research or further explanation in order for me to try to still be able to utilize my dorm, which is general population dorm, where I do have friends and I do have some type of comfort there, in order for me to be able to access the classroom? Or simply are my options from working on my bunk or to the extreme of being behind a closed door for 24 hours?
Like, I'm giving you options, ma'am. You pick which one you want.
Captain?
Judge, I'm not objecting to that question. It calls for her to speculate at this point as to what all the other alternatives may be. She's simply here to, responding.
That's the lawyer for the jail, and he's like, I've had enough. He's like, we're an hour into this. I've had enough.
As to this particular request, and now she's asking her this kind of this broad general question about alternatives.
The objection is sustained.
In regards to number 4, earphones or headphones.
So they just move on. She's not going to give her all the options. Sarah Boone has heard. She can pick whichever one she wants.
I would need to consult with legal because I don't know what the ramifications of that is. We've not had a pro se inmate ask for earbuds or headphones.
And she says a pro se inmate, but we've brought earphones. We have given earbuds that are appropriate to the jailer that the jail approves, left them there for them to use to listen to something in discovery. So there's ways to do this. And they keep saying a pro se defendant hasn't done this before, which maybe that's correct. I don't know, but there are absolutely scenarios where they have provided, they don't let them take them back to the bunk with them, obviously, but they have provided earbuds or earphones or ways for them to listen to discovery or things they need to while in the jail.
I would have to defer to legal counsel and my chain of command for guidance in that request.
And she keeps saying, I've got to defer to legal counsel, and he's right there, and he's already piped in a few times, and he's about to pipe in a lot more.
With regards to number 5, internet access. Again, we've not had a pro se inmate, or at least not one that I've been responsible for, request internet access without limits. So again,
Did you hear her say without limits? I think the without limits is the interesting little portion we have to remember as we discuss this.
I need to refer to legal counsel with legal counsel and my chain of command to get guidance on that. Regarding number 6, a word program. We've not had pro se inmate, again, myself, that requested access to a word program. I would need to consult counsel, legal counsel, and my chain of command for guidance before we can make a response. Number 7, telephone access. In her statement here, as you are aware, my dorm contains payphones only and are limited to only 15 minutes per call, which are collect. I need to be able to communicate on a regular, normal phone to make all necessary calls. Hold on, I'm turning the page. For my case to use in trial. I have no other way to contact anyone that is not collect, which incredibly, I believe that diminishes. I don't know what the other word is here. If not all of my opportunities to properly prepare. The phone system that we currently have in the jail for the inmates to access is as is. I don't have the ability to make any modifications. Number 8, discovery hard copies. It seems that Ms. Boone already has access to her hard copies. The concern I have to do now is do some research with legal and my chain of command, because that quantity of paper can potentially become a fire hazard. And we have standards in place. And Judge, I'm not certain if you're familiar with the Florida Model Jail standards, but the quantity of paper is actually the problem. So we may have to come back to the table for a different type of resolution regarding the 2 cases of paper discovery.
Giovanni's and the Orange County Jail's position with regard to the earphones, headphones, internet usage, word processor, telephone, and the concern regarding the hard copies and it being a fire hazard.
I do, and I was also including number 3, the classroom utilization. I just want to make it clear and in open court that I want to have the understanding with everyone that it is an option of mine to decide to remain on my bunk with this discovery in the laptop, and it is or my option to be moved, but I have the ability to make that decision.
Judge, I have no objection to that. I am not looking to impede anybody's ability to access to a general population housing unit. I was simply offering an option that would be amenable to security and potentially Ms. Boone.
Okay. Am I able to proceed?
You can.
So for my understanding right now, you need to speak to your legal counsel already have, is that correct?
Read your letter correctly.
Reasonably, I would like to have access to a regular phone. It could be 1, maybe 2 times a week where I save all of my calls for a particular day. I'm always up for solutions, just whatever it is that I can do in order to progress properly and expeditiously. I'm trying to do so by having this where I am confused why this was not all solidified prior to the implementation of the laptop. So I'm waiting for whatever it is that I can do to fully
I love when she uses like bigger words than necessary, you know?
access and become a pro se defendant and inmate. Do you know when, how long the deadline might be for the open-ended items that I would be waiting for?
Judge's discussion. I'll chip in with the legal piece of it.
And here he goes. Okay. So now let's tell me what you think this guy thinks about Sarah Boone. And he's about to argue against all of her requests and kind of make the same points you guys are saying, like, hey, you're an inmate. This is not a spa. You're not on holiday. You're in jail.
The legal piece of it is simply that she's a pro se inmate. She's not the first pro se inmate that the jail has had. We've had several. And the issue is whether or not there's any constitutional or statutory violation with what we provide pro se inmates. And I would argue that there's not. She has access to the court as required.
He's saying the question is, are we violating our constitutional rights? And we are not. This is what we do for every pro se inmate. WD-40 said, you still have to work within the law, Peter. They are not legislators. I agree with you. That's why I said for this discussion, what should it be? What do we think it should be? Because I will just tell you, people and lawyers in Florida that sit on rules committees, they come up with the new rules and what's fair and what should a pro se defendant have to be able to represent themselves, especially if they're an incarcerated pro se defendant. And they don't just say, oh, because it's always been this way, that's it. We have changed every rule virtually in the civil rule system in Florida about snail mailing it and waiting 8 days and putting a stamp on it and writing it this way to now electronic, e-file, e-transfer, email. We have updated all of that, sending a link, providing a Word document that is editable, no longer even using PDFs for certain things. So we definitely bring it up with the times. I'm sorry, the camera keeps not focusing. It's bothering me. But we bring it up with the times, and should we with criminal defendants as well? And he's about to say, and he almost laughs when he says it. So keep an ear out when he says, listen, basically they're given a pencil and a piece of paper, and that's what they have to represent themselves. Does that seem fair? Like a word processor on your computer to me is so simple and easy for the jail to do, where you don't have to give any internet access, but let them be able to type. Having a jail email doesn't seem impossible. It's actually cheaper than sending letters and easier, and creates less manpower that's needed to send an email versus a letter, and can be instantaneous. And we want her to be able to be prepared and know what hearings are coming. So why can't we have some kind of email system and some limited internet access so she can see the docket? Like, is she really asking for a 5-star resort? Right? Let's ask ourselves that. I realize how we feel and how people feel about her specifically, but just think about a criminal defendant across the board who's in a position that they have to represent themselves or they want to represent themselves. I don't really think some of this is such a crazy ask that this lawyer is going to really turn it into here, and this is how he feels, and we'll listen to it.
By the law, everything she wants is over and above, what our typical stance is for pro se inmates, and all those policies are in place for a reason. But somehow she wants to go beyond that, and she wants all this extra consideration, more than anybody has ever been given, frankly. And at the end of the day, again, it's a constitutional question. Is it a violation of her constitutional rights, the restrictions we have in place? And I would tell you it's not.
Is that a position, Counselor, that you're taking today? Because Captain DiGiovanni had stated she needed to consult with legal counsel as to the issues of the headphones, internet, word processing, telephone issues. Is that the position that you're taking today, or is that something you need to further investigate to have a final position as to that?
No, that's my piece of it from the legal end. Now, of course, she's got to talk to her folks as far as the security end of it, because a lot of those things are in place because of security concerns. But from a legal concern, I can easily answer that today. And the answer again is, legally she's allowed access to the court and all these other things that she wants. And really, and I'll tell you what the case law says. The case law says if she's pro se, she's entitled to get, a paper, a pencil, and some stamps and some envelopes and those types of things. The idea that she wants unfettered access with the.
You hear how he chuckled at the end of it? A paper, a pencil, some stamps. Peter, as someone who has worked in the jail, it's a lot. People at the jail wouldn't have to do a single thing more. Somebody else, some IT person at the jail would upload whatever program on the computer. The people at the jail would just give her the computer, take the computer, give her the computer, take the computer.
Phone, and she wants to make calls all day and night. At the end of the day, I'll also say there's case law out there that says, she's gone through, I think, 8 attorneys in this case, and she has several attorneys appointed to her case, and she's kind of put herself in this position today. And the case law is not real favorable to folks that put themselves in that position.
So I don't love that he said that. Obviously, you guys are going to know that. I don't mind a lot of what he said, and I think a lot of his arguments hold water, and they're correct, and they're exactly how it's been done. And if we're looking at precedent, I think he's making the right call and making the right argument, and that's fine. And he doesn't want any extra work for anybody at the jail. They don't want to recreate the wheel here, wait till the law changes. I'm totally fine with all that. Totally fine with all that. But to say that, she's been appointed 8 attorneys to make it seem worse than it is, he should have just said, the court has found that her actions have put her in this position. And it is what it is, and now she's got to deal with the consequences. But she did not run off 8 attorneys. Okay, we've been through this multiple times. She did not run off 8 attorneys. She ran off enough attorneys to where the court felt like it was enough, and that's fine. And I think that's a logical and totally reasonable decision that the court made. But I just like to, be fair. I just like to be fair, even with people that we may not like.
Ma'am, do you have any other argument with regard to these requests as to the headphones, internet, word processor, or telephone?
So my understanding is that I'm being penalized by Orange County Corrections Department because of their misunderstanding in regards to my, in quotes, 8 attorneys prior. Is that why I'm unable to have anything?
I'll tell you right now, this is all going to be something that's in the appellate record as well. And here's the other difference, okay, on appeal, right, from these cases with some other cases, and this lawyer saying, like, we've never had a pro se defendant that we've given this, that, or the other. Well, let me just ask you guys a question. Same thing as like a hospital. Hospitals can be like, oh, we've never given somebody this, that, or the other. But did they ask for it? And in the law, if criminal defense attorneys don't ask for something or don't do something, it can be considered waived. And they obviously wouldn't get it if they didn't ask for it. If she asked for it and it was reasonable and within her rights and they say no, it could be an appellate issue, even though they had not done it before where somebody didn't ask for it. It's just an interesting, right? This is what we do, folks. I'm not making the decision. I'm not the judge. I'm not the criminal defense lawyer, thank God, in this case. We're talking, we're thinking, we're using our brains, right? That's the point. That's what I hope to get out of this channel and in our discussions. And my thought is she's asking, so they are having to say no. That's very different than like a Darrell Brooks, who he wanted to ask for grounds and is the plaintiff here and you can't tell me to do that, judge, and I'm going to stand over here and I want to wear my orange jumpsuit today. Very different than what's going on here, right? Would the CPS worker who investigated Sarah for zipping her son in the suitcase be able to testify she warned Sarah of the danger, or too prejudicial? Can Sarah open the door by saying she didn't know it's dangerous? So she can potentially open the door. I don't know if they did a Williams rule hearing of other bad acts. It wasn't a crime that she has been convicted of, so they can't automatically bring it in. I don't know. I don't know what all evidence they're going to bring in. Hey, Peter, off topic. Could you please wish a happy birthday to my head of language department, Mr. Kamal? Happy birthday, Mr. Kamal. She wants the same freedom all her previous attorneys had before she chased him away. Not going to happen. Yeah, I mean, this is a lesson learned. You need an attorney. You want an attorney. Do not do this yourself. Given that the court made her pro se, denying the little things could potentially sum up to reversible error, they should have indulged her on the things that aren't hard to do. Yeah, somebody else said, just give it to her. She's not going to win. Right? But the point is, like, we just want it to be fair. That's it. Peter, it seems like pro se is more like a punishment to the system than Boone. Do you think lawyers, jail staff are upset the judge for the pro se? They're not upset at the judge. They get it, but I will tell you, we all hate it, including the judge. Everybody hates it when somebody goes pro se. It just makes everything more difficult. If somehow she gets a mistrial, will she be forced to be pro se again? Most likely, yes, unless the judge thinks something has changed. All right, let's keep listening.
In order for myself to properly represent myself as a pro se defendant and inmate of the Orange County Corrections Department?
I'm not going to answer that.
Not being penalized, just the opposite. She's being treated like every other pro se inmate in the institution. She's not being penalized at all. She wants consideration over and above what everybody else has.
If I may please, what is over and above? What other pro se inmates, what is it that they've asked for? I don't see how they could successfully even represent themselves without internet and a regular working phone. And
that's the point. They usually don't successfully represent themselves.
I'm pretty sure that they were not able to complete their case in the successful outcome that they were hoping for by being provided simply papers and pens.
Counselor, if you...
I'm not sure if she's asking me a question. I don't know if I'm a witness in this case or if she's trying to ask me a question.
I'm not. You're just simply...
Now he really is just, he's like, have you ever seen that meme? Oh, you want to F with me? That's like what he's doing. He's like, no, you don't get to ask me questions, Ms. Boone. You don't get to ask me questions. It's like, no. I'm not answering that. I don't have to answer that. And it's almost a little bit like, oof, Sarah Boone. Like, the law is coming at you fast. It ain't easy being a lawyer. Right? It just is not. And it is not easy representing yourself. It's not easy being thrown into a system where people are trained killers. Literally. It's like, it's a very tough world. Sharks circling the water and they know you don't know what you're doing. So if they're going to get contentious with you, it's usually not going to go well for you. And that's what she's doing here. And the lawyer is just like, I'm not going to tell you that. I don't have to tell you that. I don't have to answer that.
The attorney for one of the participants, sir. If you're under no obligation to answer that question. You are just providing your legal position with regard to the Ms. Boone's demands and requests.
They're simply requests. And I'm not sure who it might be that could answer my question, please, in regards to what prior or present other pro se defendants and inmates have requested. So I might have a guideline of something to go with forward. And I, again, do not know what is above and beyond simply asking for more than paper and pens in order to properly and rightfully and lawfully represent myself.
Counselor, to the extent you want to respond to that, you can.
Yeah, I mean, Judge, like I said, we've got tons of pro se inmates who have come through. They're there right now that have come through the jail, and they get standard treatment. And she wants a lot of them go over and above that. For instance, again, unfettered phone calls. She wants to keep things in her cell that she can't normally keep, that they wouldn't allow folks to keep. There's a lot of issues. I mean, that's a wide open question. But can I speak to everything that everybody's got in the past? How many pro se inmates we've had that have come through the institution? No, but I can tell you that we could probably find plenty of examples if need be as to what people have received in the past, and it's nothing close to what she's requiring or requesting today.
Ma'am, with regard to your state, do you have any position with regard to any of these matters we've addressed? Okay, thank you. All right, ma'am. So with regard to your request as to the laptop, this jail will be able to accommodate your request, and those extensions will be provided as placed previously on the record. With regard to your request to hold the USB drives in your own personal lockup, for the reasons identified by counsel Chevenel, it's a matter of security, and the protocol which secures, controls, inventories, and ensures in good working order the USB drives will be complied with, so that request will not be accommodated. Your request for a classroom similarly cannot be accommodated for the reasons identified by Captain.
The judge is about to run through a slew of L's that Sarah Boone is going to eat during this hearing. She lost on internet, word processing, classroom, phone, etc.
Giovanni on the record. However, there is an alternative housing offer that can be provided for you. With regard to your request for headphones, that has been rejected and denied by virtue of the legal counsel's argument and what is being provided to you. With regard to the internet, word processor, and telephone, again, for the reasons that counsel for Orange County has identified, those cannot be provided to you. The court does note that you do have the services of an investigator. And JAC.
It's almost like that guy's probably sitting back there like, oh no. It was like, he's basically like, treat your investigator like your lawyer, tell him stuff you want him to go research or calls you want him to make. He can talk to witnesses for sure and write up witness statements for her so she knows what the witnesses are going to say. So if she was a lawyer and knew how to use an investigator, that could be really helpful for the phone calls, but he's not going to be able to do all the research that she's going to want to do or type up the documents for her motions. So she's still stuck handwriting letters and motions.
Provided you $10,000 and $1,000 for travel for your investigator. To the extent, as requested for the purposes of internet, for locating witnesses and experts, you have a personal private investigator that can utilize, he can do that for you. I know you've made requests previously to look at your phone to find contacts and information. You also have a private investigator who would accomplish some of those tasks for you. And those can be communications and conversations between yourself and your investigator as to who and when and where and what persons you might be able to seek to find. So for those reasons regarding the headphones, internet, word processor, and telephone, based on arguments of counsel for Orange County, I'm unable to accommodate those requests. The jail is unable to accommodate those requests, and those requests will not be provided. With regard to the hard copies, that's going to have to be a matter, if it needs to be addressed, it can be readdressed with regard to the potential fire hazard. Captain DiGiovanni, would that still be an issue with regard to the fire hazard based on the amount of paper if Ms. Boone elected to move to the secured house?
So they're going to get into now the boxes versus the fire retardant bags that they could put the paper in. So we'll listen to kind of how they accommodate her with that, which I think is nice of them. And they're trying to work with her, but obviously fire hazard and things like that are really important. There's 400 inmates in this jail. Peter, how many other defendants are pro se by circumstance versus by choice? Mostly by choice. It's more unusual for them to be by circumstance, which again is an added element to this that we can't just throw out, even if we agree with the decision by the judge. Peter, can this legitimately be considered a fair trial? Legally, yes, but you're seeing the issue. Peter, not literally, Bud, you're not a killer. Yeah, clearly, very clearly. Yeah, good job picking up on that. Britt, they should update access for people representing themselves. However, maybe not be so hard to work with that you have to represent yourself. Do not expect the world to be at your whims. You must bend to the world. So I don't know about always bending to the world, Britt, but I get what you're saying. And that's the point, is this ain't easy. You should have, guess what? All of these things you want, the discovery, the motions, the research, the telephone calls, the witness list, the exhibit list, viewing the exhibits, you had a person trained and dedicated and educated and experienced to do this on your behalf, and you poo-pooed it. That's the problem. And Johanna said she should know how much her attorneys did behind the scenes. Yeah, she was complaining they weren't doing anything, and at least Ms. Cashman really put it on the record how much time she spent with Sarah Boone, and then all the other stuff she did not with Sarah Boone. Should the lawyer have been sworn in? No, that's exactly the point. He wasn't a witness, so we don't get sworn in as lawyers when we're making arguments representing people or parties. RS, how can she do case research without internet? So some jails have libraries. Sometimes they have access to certain things. But again, if they gave her limited internet access to just some kind of case law in the docket and email, not unfettered, but maybe she could only email the investigator, the JA, the state. There are ways to do this, guys. And I know people are like, oh, that'll be a nightmare. It's so hard. Honestly, is there anything more important than our freedom? And if we were in this position, what would we want? What would we think is fair? Technology is not that difficult today. Frankly, AI could write these motions for her, right? I mean, I'm a proponent of fundamental fairness and justice, and I don't think it's going to create an unjust result. Let her have her time to represent herself and do the job, and then the jury's going to return the verdict the jury's going to return. I just don't want anybody railroaded. And again, that's it. It's kind of my thought on it, but we'll listen to the rest of this hearing.
Housing in the K dormitory?
It's basically the Florida Model Jail Standard 7.12. The officer in charge or designee shall determine what personal items may be kept in the cell or stored with the inmate. However, an inmate shall be allowed to retain a reasonable amount of personal property, including but not limited to his or her legal material, personal hygiene items, writing paper, and writing instrument, and authorized reading materials in reasonable quantities as approved by the officer in charge or designee. Personal items will be kept in an orderly manner.
I get everybody saying I wouldn't have put my boyfriend in a suitcase. I get it. That's not the point, guys. That's not the point. Come on. We have to know that at this point, that's not the point. The point of the justice system is how it affects everybody, not just somebody you think is guilty, because how it affects her is going to affect somebody you think is innocent. And we have watched cases of people you think are absolutely not just not guilty, but innocent of the crime charged. And if this could happen to her, it could happen to them. And that's why it's important that all the rules stay the same, whether we think somebody did something or think that they did not.
Fire potential is reduced by limiting the amount of personal property in the cells. So it is the sheer volume of paper, and that is what I need to conduct an evaluation from. Now, in Ms. Boone's letter, if you give me one moment. The remaining I can send to the property department and will purge anything already being stored for easy convenience and extra space. I am willing to see what she's going to purge and send to property, but at the end, I have to reduce any fire liability to the building in order to maintain security and safety for the 399 other inmates that I have here, along with the almost 100 or so assigned staff, civilian and certified.
So some really good comments and questions coming in, and some people are angry, and I get that, and it is what it is. Yeah, but you sound like you want to give her special treatment, and that's missing the point completely, et cetera. Missing the point completely. That's why I'm saying it's not just about Sarah Boone. It's about everybody. These things I'm talking about, limited internet access, a word processor on the computer, I would want to give to anybody representing themselves. That's what I'm saying. It's not specifically about Sarah Boone. And Boone's Farm said it. Exactly, Peter. I'm not even considering Sarah Boone. I'm thinking of what this Boone, meaning this person, should have if I am ever accused of a crime, of another crime. When the Constitution was written, there was no internet. The Constitution is the beginning, right? All states have their own statutes and laws and rules and case law, and it is always adapting with the time, right? I'm not saying that rights go away, but I'm saying how we communicate with each other has changed. How we file things with the court have changed. How we pay for things has changed. And we update the rules and the laws accordingly. Have you seen or heard Donna Ailson's new motions? No. If you guys want to hear me break those down easily, I'm definitely covering that case. That case is super interesting to me. So if you want me to break down a motions hearing, let me know, send me the links, and I can take a look at them. Shouldn't she have a way to make unmonitored phone calls? She is her own lawyer now, and any investigation she does with witnesses would be privileged. In my opinion, honestly, not unfettered, not unmonitored. Like, they should still be able to monitor, but like somebody in the jail that has nothing to do with the prosecution team, just to make sure she's not doing anything illegal, but they couldn't be used against her. It wouldn't be like normal jail calls. There are ways to set things like that up, but I think the better way to do that is through her investigator personally.
I will also say that pro se inmates in the past have been afforded a second fire retardant property bag, and I'm willing to issue a second fire retardant property bag to accommodate the excess, but anything over and above that, we may have to find an accommodation. And based on the willingness of the letter that Ms. Boone has written, she articulates clearly that she's willing to purge and send to property any paper that's over and above.
Do you have any questions?
And
No, go ahead.
And I can have that second property bag upon her return this evening.
Okay. Ma'am, do you understand the second fire retardant bag that can be provided to you regarding the hard copies of the discovery?
I do, and it was already provided to me, but the boxes unfortunately do not fit in the bag, where I did attempt numerous times and even had others try to help me put it in the bag. I also did not know that they were fire retardant bags. I have the one already at my bunk, and I'm in the process.
So Velo, they're saying the boxes, I guess, that they come in are a fire hazard, and like they're encroaching on other inmates' spaces with how much paper she has and things like that. They talk about this for a while. I'm going to skip ahead a little bit. And they said they'll provide her with some manila envelopes so she can keep it organized and things like that. But I'm going to skip some of this. Kind of boring.
So ma'am, if the jail was to provide you those manila folders for the hard copies and a third fire retardant bag, is that acceptable?
It is, if I do conclude that I need anything additional in order for them to be able to be held together in regards to some type of rubber band or some elastic, something to be able to bind the paperwork together. Is that a possibility?
No. Rubber bands, a big no-no.
I didn't hear the question.
You may have to speak more clearly into the microphone in front of you, ma'am.
Would I be able to, please, if I needed, to have a type of rubber band or some kind of elastic in order to bind?
No.
And I know, Captain, that you are aware the courtroom is not in regards to the property bags that you all do supply. There's no rigidity to them whatsoever.
Is that
Mr. Chevamel,
Yes.
could you please provide me with the protocol or policy that you will have a guideline for me to follow, please, in regards to what previous pro
She hasn't figured out that she's barking up the wrong tree asking him for anything.
se inmates may have had access to and be able to utilize? Do you have anything in writing as a hard copy?
We'll have to check on that. Are you making a public records request?
I'm sorry?
Are you making a public records request?
He's like, go ahead and make a public records request.
I'm unclear of your question. I was just asking if Orange County Corrections Department had any type of guideline that you are accusing me of going above and beyond, other than the pen and paper. So I didn't know if you had a policy or process in, if you have a pro se packet, like JAC has a pro se packet. Does Orange County provide something like that?
You have to ask the jail that question. I don't know. I advise from a legal standpoint, and I can certainly tell the jail what the legal standard is. I'm not going to advise you as to what the law is, but I'll certainly advise the jail as to what the legal standard
He's like, I'll talk to the jail about it, but I'm not going to talk to you about it. I'm not going to tell you anything.
is.
Which again, well within his rights. Maybe the way he says it is not the nicest, but he's not wrong.
Yes, please. Captain, I would be responding to you in regards to that or following up with you, or Sergeant DeJesus.
Ma'am, we don't have any access to that. I don't know anything about what other inmates that are currently pro se get other than that laptop and the information transferred to a USB drive.
Yes, ma'am. Thank you. And Mr. Chevamel, you repeated that I have access to the court. Could you please define to me what your access to the court is for me?
Yeah, I'm not a witness in this case. I'm really counsel for the jail, so it's really not appropriate to ask me questions. I know I've entertained a few, but
He's like, objection. I don't want to answer that one. I'll answer the ones I want to, but not the ones I don't.
I'm really not required to answer any.
Ma'am, he's not in a position to answer those questions.
Judge is like, nope, 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 nope. Hey, everybody, hit the like button. Hit the like button if you haven't already. But Peter, a reasonable person would have a public defender who could do all the things she's requesting. She put herself in this position. So Sussex Sandra, I will also just tell you, there are really, really great, good, strong, experienced public defenders. There are also some really horrible public defenders that I do believe people think they could represent themselves better. And if that opportunity should arise for somebody that feels like they're innocent and they could do a better job representing themselves, it should not be a death sentence. It should not be a guaranteed loss. Right now, it kind of feels like it is. She's not requesting sophisticated tools, just tools considered basic in 2024, things a second grader uses daily. Hit the nail on the head, Michelle. My kids just started school. Have to bring their laptop in, and in 5 minutes, they put all the antivirus software, block all the websites they can't use. They watch their computer, all that stuff. In about 5 minutes, everything's on there. My third grader, uses laptops and computers and tablets and stuff at school. Hi, Peter. What do you think the odds are that she will settle? Do you think she will fight the video as evidence? I think she's going to try to fight everything. I don't see how that video doesn't come in. I think there's a 50-50 shot she takes a plea deal. I think she is considered, maybe even 60-40 she takes a plea. I think it depends on the amount of time the state wants her to serve, because I don't think she hates jail. Honestly, I don't think she hates it, if you want my opinion. She's talking about her friends in there. She doesn't want solitary, etc. I get why the judge made her pro se, but this also sucks. They could accommodate her more reasonably. She is already at a huge disadvantage. Right. And I mean, when you say accommodate her, I say accommodate her, people see that as special treatment. I mean, everybody. This is a discussion to me and an opportunity. I love when videos in real life cases provide us with the opportunity as society on this channel, in this chat, to discuss how things should be, right? how they are, we discussed, but also how they should be. What accommodations should we afford to criminal defendants who represent themselves in America? That's kind of the question and point of this video.
Could you please answer who might be able to? Because I am in desperate need to view the case docket, which requires internet, and I am still waiting for any documents that you have mailed to me. I am unprepared, it seems, every single time now sitting here at the counselor's table with not the same information and opportunity and advantage as everyone else in the courtroom because I'm waiting for the mail. So I didn't know if anyone had any other suggestion of how I might be able to receive those more expeditiously and in a timely fashion so I can be prepared in order to properly defend myself in apparently more than one way, or every time that I'm here in the courtroom and something new is presented to me as a surprise. So I'm just trying to avoid this.
Items will continue to be mailed to you at the appropriate address as required by the rules of judicial administration and general practice.
So if I may please clarify, my understanding is the only way that I can receive anything is through United States Postal Service.
I'm not going to answer that question because that would be me potentially providing you legal advice. But what I can tell you is that items will still continue to be mailed to you as required by those rules.
If I may please just make sure that everyone is aware that I cannot be properly prepared, as you can see now and prior. I just want to make sure that everyone is aware and understands that.
Ma'am, for the reasons that we've discussed previously, I understand that. You're entitled to that opinion as to your pro se representation of yourself. Anything else that we need to address today? Ma'am?
Yes, I have a motion that I would like to submit, please.
Okay. Is there anything else that the jail needs to participate in with regard to this hearing?
Captain, would I be following up with you, or who would I be speaking to when I return to the dorm?
In regards to what?
I'm wondering in regards to the guideline and when and how the discovery hard copies, will the property bags be waiting for me when I return?
I will take care of that with my supervisors that are on shift.
Yes.
We will need the cardboard box so that we can dispose of that properly.
Yes, ma'am. And if I may, do you know why it was not approved prior when a supervisor was the one who delivered it to me?
I have no information about even the amount of hard copies. I didn't even know that came into the jail because my conversation has always been that everything would be digitized and that we would have no hard copies so I could be in compliance with the Florida Model Jail Standards, Orange County Fire Marshal, and our policies and procedures regarding excess amount of paper.
Yes, ma'am, I understand. Thank you very much for your time. And Sergeant DeJesus and Mr. Chebamel.
Okay, are they free to leave?
Yes, thank you.
State. All right, thank you all very much. Ma'am, you made reference to another motion or something else that you had.
Yes, I have a motion.
Okay, if you hand it to the deputy behind you. Deputy, can you hand it to the state? State, you can take a look at it and then I will. Probably hearing on this without JICS.
So
State takes no.
we'll listen. The judge will tell us what's going on. We're not going to get an answer to this, but we'll hear what this is about.
State? I don't think we can. Court has been provided a motion
A new motion Sarah Boone just filed.
for payment of costs and appointing a neuropsychologist to assist the defendant in preparation of the defense.
She wants a neuropsychologist to assist in the preparation of the defense. They can't do anything without JAC to talk about, they've got the purse strings.
State? I don't think we can have a hearing on this without JICS.
State takes no position. We don't have anything to do with this.
Okay. Ma'am, I can't have a hearing on this today. I'll have to coordinate a hearing with JICS to have this heard because this is something that involves them.
Right.
And they haven't even had the opportunity to review it yet.
And they are copied on that as well.
I do see that, but you're hand filing it with me right now.
Right, thank you.
So the court will,
Are copied on that as well as if it's an email. He's like, yeah, but you just handed this to me. So that's not the way CC works. When you hand me a piece of paper, they don't automatically know about it just because they're copied on it.
we'll file this in the court file and we'll coordinate a hearing as soon as practical with regard to this motion, and it'll be heard before the end of this week. Anything else, ma'am?
Just to confirm, please, for the next deadline for my responsibility to meet would be the August 23rd for the objections to the state's USB drive that they provided.
As identified in the court's order, that is the deadline. The only other deadline, ma'am, is the September 3rd deadline for the viewing of the state's physical evidence, which sounds like that's something that may take place prior to that deadline. As you may recall, you'll have 14 days after that evidence viewing to tender any of your objections in writing to the court, 14 days thereafter, and that will be extended for good cause shown. Anything else, state?
Nothing state.
Ma'am, anything else?
No, Your Honor.
All right, we'll return Ms. Boone back to the custody of the Orange County Jail, and we'll coordinate the hearing appropriately. Thank you all very much.
All right.
Forgive me.
We'll get her last statement. I want to answer a couple of these questions, though, because they're good. Peter, why don't you advocate for changing / updating how pro se's can defend themselves? I like it, and I will. I'm not on the criminal rules committee. I'm on the civil rules committee, so it's a little different. And most of the rules committees I'll be on in the future will have to do a civil. My dad is always on the criminal justice committees in Florida. I'll talk to him about it, see what he thinks, and see what we can do. Courts have been around for 250 plus years. Them not having a pro se system better than this is just pure incompetence or negligence, or it's just they don't really care, right? Maybe they don't really care about criminal defendants that represent themselves, which is sad. And it's not how it should be, especially for lawyers, right? There is a lot going on. There's a lot to fix. There's a lot to work on. There's a lot of reform happening all the time. So maybe it's not on the front burner, as they say. Inmates have access to the internet, i.e. inmate TOK. It's really different depending on the jurisdiction, what they can actually look at and what they can't. So it's hard for us to exactly know what she can and can't do. Fletcher boy, Peter. Wasn't her last attorney a very experienced trial lawyer, even DP certified? I don't know if she was DP certified. Wouldn't surprise me. Yes, she was very experienced, seemed like a very good lawyer. We broke down her experience and her education. That's a mistake that Sarah Boone did not work with her. We said that from the jump. But we're past that. Whoops. We're past that, and we're dealing with the issue that's in front of us now, right? I mean, that's the point.
In order possibly for a solution for me to know about the hearing, especially for the one regarding the JAC, is it possible for you please to relay it to Mr. Lane and he can tell me sooner than the mail?
I can certainly do that.
Going forward, so I would have some opportunity quicker than waiting for the mail.
I can certainly advise him of that, or my office can. Sure. Okay, I understand. All right, just so for recap purposes, with regard to the motions to intervene as first addressed this afternoon, the court orders that the defendant has failed to meet the burden of producing evidence. And
all right, so then he just kind of recaps what we already know, what we already saw from the hearing. Peter, do you think that holding back some things like unfettered internet access and phone protects her and others from her? So it would never be unfettered. It would never be unfettered. I would never think it'd be unfettered. I'm telling you, like, when I take my computer to my kid's school, they put all these protections on it in 5 minutes. There's ways to protect the stuff that the jail controls the computer. It's not Sarah Boone's computer, right? Michelle, attorneys come with laptops, legal versus legal pads, stenographers dictate versus type. Seems every other player has been allowed to upgrade their equipment. I mean, it's just common sense, right? It's just common sense that there's a big difference. Can you imagine if she used this candor and smarts in her life, honestly, rather than on her own defense? She could have done so much. Oh, it seemed to be a bad decision maker a lot of different ways. And I don't think that's going to change now that she's just representing herself. But that's all we got. I appreciate you guys joining me for this nighttime live. Let me know what you want to hear. I know that Robert Tellis, I think is his name, trials going on. Donna Adelson motions. We've had a couple requests for different things, but kind of sporadic. Nothing where like everybody seems to be on the same page asking about the same stuff. So I love to hear what you guys want to talk about, what you guys want to hear. So please let me know. Hit that like button and make sure you subscribe, because if you subscribe, you can help us pick what content we're doing next. But that's all we got. Till next time, I'm out of here. Thanks for watching another episode of The Lawyer You Know. If you enjoyed the episode, please hit the thumbs up and share with your friends who may be interested here on YouTube. And don't forget to subscribe. You can also follow us on Instagram, Twitter, Facebook, and TikTok. And don't forget to check out the Lawyer You Know podcast with new seasons dropping every quarter. If you have a case you want to talk to us about, if it's a personal injury case, wrongful death, catastrophic injury, car accident, or slip and fall case, please email us at lawyeryouknow@gmail.com. And of course, all these links I just mentioned are included in the description below on this episode and every episode. So until next time, this is Peter Tragos, The Lawyer You Know.